On this show, we have talked a lot about economic development. Over the years, the state has invested in many companies, giving them tax breaks, grants, or other incentives in exchange for pledges to create jobs here in New York. Most recently, for example, the state promised upwards of $40 million, taxpayer dollars, to BAE Systems, that is a defense contractor with a plant in the southern tier. It flooded over the summer when remnants of Tropical Storm Lee came through. My next guest says that all of these handouts to large corporations are actually unconstitutional. He sued to stop the practice. He took his case all the way to the highest court, the Court of Appeals. Unfortunately, this week, the case was dismissed by New York's highest court. He is attorney Jim Ostrowski. He is joining us from Buffalo this evening. Jim, thank you very much for being here.
Thanks for having me, Liz.
So have you processed this? I know that you wrote online that you felt like you couldn't even get your arms around it. You've been fighting for a long time, years, if I'm not mistaken. So have you had time to think about it?
I have, and we've decided to move forward and use whatever tools are available to reverse this decision.
Well, what does that mean?
Well, the one tactic left in the court itself is a motion for re-argument. And I talked to Lee Bordelot the other day, and we decided to make that motion. We're going to make a motion and ask the court to re-argue, and at least to have two judges change their minds and rule against corporate welfare.
That's fascinating. Do you have any idea how often the court actually decides to rehear a case? I didn't even know you could do that. I thought once it was over at the highest level.
No, we have basically almost every court, in almost every court, you have the right to re-argue. It's not granted very often, but in a case like this with two strong dissents, in their complete confidence in our legal position and given what's at stake, which is absolutely enormous, we decided to make that simple motion and not give up the fight.
Now, you just mentioned Lee Bordelot. He is the plaintiff in this case, and you're the attorney. You guys were both here with me not so long ago, actually, when we first learned that the court would hear the case. And we were really floored. And as I tried to tell viewers, it would have been huge if it would have really upended the state's entire economic development policy had the court ruled in your favor, right?
It would have, and perhaps that's why the court was being cautious. But we agree with the dissents that the court's job is to enforce the Constitution and let the politicians worry about the consequences. But we believe the consequences would have been absolutely wonderful for the state of New York, ending this corrupt practice of corporate welfare, which is really the glue that holds the whole corrupt regime together in New York State. Yeah,
actually, the dissenting opinions are almost more interesting than the decision itself, actually, which was not in your favor. I mean, there are two justices, I think, who wrote in the dissent, and really, particularly, Judge Piggott and also Judge Smith were quite harsh, I think, and you should correct me. Did you find it that way, too, in their assessment of Albany?
I've never seen a stronger dissent. Judge Smith said that the majority had judicially repealed the gift clause.
Yeah, explain what that is. Explain what that is.
Well, the gift clause put in going back to 1846, but specifically put in 1874, banning gifts to private firms. This goes back many, many years. It's been amended many times, but not replaced. And most significantly, as Judge Piggott noted in his dissent, the people rejected a change in 1967 that would have done exactly what the court's decision did the other day. So I understand Judge Piggott and Judge Smith were really upset with what the majority did, as are we.
Yeah, this part I find absolutely fascinating. This is from Judge Smith. He writes, quote, "I seem to remember a time when IBM could make money by selling its products for more than it cost to produce them. I would have thought semiconductor manufacturers could do the same. If they cannot, a bailout for their shareholders is not a prudent use of more than $1 billion in taxpayer funds." I mean, that pretty much encapsulates your argument right there, doesn't it?
Well, that's our policy argument. We oppose all forms of corporate welfare for a wide variety of reasons. They're wrong, they're immoral, they're illegal, they violate equal protection, they don't work, they haven't worked. I could go on and on and on. But there's also very strong legal arguments against them, which we put forth in this case. And we just vehemently disagree with the court's decision.